Welcome to Rapid Fire Wednesdays, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in our San Diego office, and I'm joined, as always, by Miki Matrician, co-managing partner of our Boston office. How are you doing this week, Miki?
I'm okay. How are you, Kim?
I'm doing good. Kind of, getting back on track after last week's craziness. So, we're going to talk this week about the proposed regulation on the H-1B cap lottery selection process. So, Mickey, last week was, as we were mentioning, a total whirlwind with the H-1B presidential proclamation, a proposed regulation, and the H-1B cap lottery process, and then Department of Labor's announcement of its Project Firewall. So, lots of information to digest. So this week, why don't we focus on the proposed regulations for the H-1B cap lottery selection that were published by USCIS?
Yeah, it really has been a whirlwind with so many proposed changes. These regulatory changes to the H-1B cap lottery, if they're finalized, they will have implications for employers that want to hire skilled foreign workers under the H-1B program. And under the current system, the number of first time H-1B petitions usually exceed the fiscal year's quota and are selected based on a lottery, a random computer generated drawing. The system is beneficiary centric, which means that each prospective H-1B worker has one entry in the lottery, even if multiple employers submit an H-1 registration for that same individual. Under the proposed changes, the H-1B selection would shift from a purely random lottery to a weighted lottery that favors higher paid positions while still giving all wage levels a chance to be selected in the lottery. Kim, can you break it down for our HR and global mobility professionals how this leveling would work?
Yeah, sure. So let's first talk about how the weighting works. The number of each beneficiary's lottery entries is determined by the offered wage compared to the existing Department of Labor's occupational employment and wage statistics wage levels for the specific occupational classification that is also in the specific area of employment. So, multiple things that we're looking at. And the Department of Labor wage leveling is based on wage levels from number one to number four. The wage level determination process is based on a few steps. So, first, the employer identifies the appropriate standard occupational classification, which we usually refer to as the SOC, and they determine that SOC code that best matches the job duties and requirements for the position offered. And sometimes it's like fitting a round peg into a square hole because they don't always fit 100%. So once we have the SOC code, the next thing is that the wage is determined based on the specific geographical area where the work is going to be performed. So, specifically, where the individual will be physically located. And then we look at the skill and experience level. So, the offered position is then classified into one of the four wage levels that are based on the minimum job requirements, with level one being for entry level positions. And then level four is for fully competent positions that require an advanced knowledge and wide latitude of judgment, essentially. So, for purposes of the H-1B lottery, if the offered salary is equal or higher than level four, the beneficiary would receive four entries in the lottery. If it's level three, then the beneficiary will receive three entries in the lottery. If it's level two, then the beneficiary will receive two entries in the lottery. And then finally, if it's level one, the beneficiary will receive only one entry in the lottery. So, for any employers using a prevailing wage based on a private wage survey and it is lower than wage level one, the company would select level one. So, if the sponsor role is slated to have more than one work site, the lowest wage would be listed on the H-1B cap registration. All right. So, Mickey, what are some other key points for our HR and global mobility professionals to know about this proposed cap regulation?
Yeah, well, the proposed rule is such that the number of entries in the lottery may not just be about the salary amount, right? It's also based on how the job requirements and the offered wage compare to the Department of Labor's statistical data for particular occupation in a specific geographic area. So, for instance, a high salary for a level one position doesn't automatically mean that it will meet level three or level four. What's important is that the job duties and the requirements must match the higher skill level definitions for the wage levels. Another key item to mention is that if multiple employers submit registrations for the same foreign national beneficiary, the number of entries allowed for that beneficiary would be based on the lowest wage level offered of all the submitted registrations. So, in past years, sponsored foreign nationals may have seen the benefit of applying for jobs with multiple employers to have them enter into the lottery. Now, with this change, beneficiaries might think twice before having a registration submitted by a company that's offering a lower salary compared with another employer.
Yeah. And Mickey, based on a review of the proposed regulation, it appears that there will be an increased administrative burden with having to document and determine the appropriate wage level prior to the registration with USCIS, which is way more than we've had to do in the past. And as more employers consider offering higher wages to gain an advantage in the H-1B cap lottery for their sponsored individuals, overall market compensation may increase. So, this system, however, disfavors companies that provide lower base salaries and make the employees whole with a higher year end bonus. And there are additional compliance costs. Can you explain these costs for us, Mickey?
Sure. Employers will be required to maintain and store wage source documentation, such as the DOL's wage search printouts for each CAP H-1B registration. And there will be likely a lot of employers that'll need to reach out to counsel for additional legal guidance in order to ensure that the proper wage level determination and the right SOC code is being used. There also will be new requirements for maintaining detailed documentation that supports each H-1B cap registration's wage determination and job requirements. Let's not forget about the additional time and resources that may very likely be needed to ensure that all registration information is accurate and supportable. So, we recommend that HR and global mobility professionals budget for these increased administrative, legal, and labor costs when planning their H-1B cap strategies. Kim, can you talk about the timeline for this proposed regulation?
Sure, Mickey. So the proposed reg is open for public comment for 30 days from the publication in the Federal Register, and it will end on October 24th. The government will then need to review all of the submitted comments. And if this rule is finalized, it would normally become effective 60 days after the final rule's publication in the Federal Register. So the new system, if published by the government and not subject to any preliminary injunctions, may first apply to the fiscal year 2027 H-1B cap season, which means the March 2026 registration period. And we expect that USCIS will provide detailed guidance on system changes and any transition provisions if this does go into effect. And Mickey, what are some of the practical considerations for HR and global mobility professionals with looking at this proposed H-1B cap regulation?
Yeah, I would say first and foremost, I'd recommend reviewing the company's current H-1B strategies and assess the impact of the wage based selection process. And essentially, looking at the wage levels for planned H-1B beneficiaries that are slated to be sponsored, and also evaluating budget implications of offering higher wage levels. And then importantly, considering submitting comments during the public comment period so that the Department of Homeland Security has an opportunity to hear from all of you. And then for longer term planning, assuming that this actually goes into place, it would be important to develop alternative talent strategies that don't rely solely on H-1B workers. So, for instance, looking at other visa categories like TN, O1, L1, etc., for key employees. We also recommend considering the timing of H-1B submissions based on business priorities. And finally, it will be important to continue to engage with Immigration Counsel to discuss strategic considerations.
Great. Thanks, Mickey. And with that, it wraps us up for this week's Rapid Fire Wednesday. And we will continue monitoring legislative, regulatory, and court developments, as well as agency guidance, and provide updates in future episodes as we hear of them. So, as always, for all the latest updates to the immigration landscape, please follow WR Immigration on LinkedIn as well as Miki and my personal profiles for breaking updates and insights. We also transcribe each and every Rapid Fire Wednesday episode and share it through our weekly newsletter, which you can subscribe to. The link to subscribe can be found in the video description. So thanks for joining us, and we'll see you next time. Good to see you, Miki, and hang in there with all these crazy changes.
Thanks, Kim. You too.